Get ready, start. Reliance was placed on a judgment of this court in New India Assurance Company Limited versus Krishna Kumar Pandey in support of the contention that an application for recall is maintainable when the order is passed without jurisdiction. The respondent in the said case was convicted for an offence punishable under Section 498A of the Indian Penal Code 1860 IPC and was sentenced to rigorous imprisonment for 1 year. The appeal filed by him was dismissed by the Sessions Court, against which he filed a revision petition under Section 397 CRPC before the High Court. The revision petition was partly allowed by the High Court and the sentence was reduced to the period already undergone. The High Court also held that the conviction shall not affect the service career of the respondent adversely. The appellant filed an application for correction of the order passed in the revision petition, which was dismissed. The respondent employee submitted before the High Court that the order cannot be modified. The High Court accepted the submissions of the respondent employee in that case and dismissed the application, against which the appellant approached this court. This court was of the opinion that the High Court acted in excess of its jurisdiction in holding that the conviction shall not affect the service career of the respondent therein. By referring to an earlier judgment of this court in state of Punjab versus Davinder Pal Singh, it was held that inherent power of the High Court under Section 482 CRPC was available to pass suitable orders where an order is passed without jurisdiction or is in violation of the principles of natural justice. The said judgment has no application to the facts of this case. By no stretch of imagination can it be said that the order dated 4/5/2000 suffers from the vice of lack of jurisdiction. Yet another ground raised in the appeal is that an application for recall is maintainable when principles of natural justice are violated. A perusal of the order dated 4/5/2020 discloses that the appellant and the other contemners were heard before the applications were dismissed. Therefore, the contention of the appellant is without any substance, as we are concerned only with an application filed to recall the order dated 4/5/2020. It is not necessary to examine the submission made by Mr. Sorkar that the judgment dated 27/4/2020 has been impliedly overruled by a later judgment of this court in Prashant Bhushan's case Supra. We are in agreement with the order passed by the Registrar Administration holding the application for recall of the order dated 4/5/2020 is not maintainable. This court in Delhi Administration versus Gurdeep Singh deprecated the practice of filing of applications for clarification, modification or recall of final judgments or orders. It was held in the said judgment that a party cannot be permitted to circumvent or bypass the circulation proceedings and procedure provided in the provision pertaining to review and obtain a hearing in the open court by filing an application for modification or recall. Stop. Subscribe to our YouTube channel Shorthand Dictation Legal Matters, but never forget to hit on like icon and share with your friends.